Good morning, everybody. My name is Margaret Hinkle. I chair the Post Commission. And welcome to this meeting. Let me call it to order at this time, and let me begin by taking a roll call of the commissioners in attendance. Commissioner Bluestone,
Good morning, I'm here.
Commissioner Calderon,
Good morning, yes, present.
Commissioner Crispin,
Good morning, I am here.
Commissioner Hall,
Good morning, present.
Commissioner Kajirosian,
Good morning, present.
Commissioner Luma,
Good morning, present.
Commissioner Talley.
Morning, present.
Thank you. We have a quorum. Commissioner Baker is not with us today. All other commissioners are present. We are members of the public. At this time, I will entertain a motion to go into executive session, and we will reconvene the public portion of the meeting at 10:30 this morning. And we're going to, I will entertain a motion to go into executive session at this point in accordance with General Laws, Chapter 38, Section 21A1, to discuss the discipline or the dismissal of complaints or charges brought against a public officer, employee, or individual. General Laws, Chapter 38, Section 21A5, to discuss the investigation of charges of criminal misconduct, the same statute, but Sections 21A7 combined with General Laws, Chapter 6E, Section 8C2, and to the extent they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss the initiation of preliminary inquiries and initial staff review related to the same, and also regarding certain criminal offender record information, and General Laws, Chapter 38, Section 21A7, combined with Section 30, Chapter 30A, I should say, Sections 22F and G, to discuss and approve the minutes of a prior executive session. There will be reports of preliminary inquiry in 8 cases presented to the commissioners. There will be Division of Standards request to enter into voluntary decertification or suspension agreements in 3 cases, and standards request for approval to conduct preliminary inquiries in 10 cases, and also approval, as I said earlier, of the minutes of the executive session of February 13th, 2025. So let me take is there a motion now to go into executive session?
So
I'll
moved.
make the motion.
Okay.
Thank you. Is there a second to that motion?
Second.
Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Kajirosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley,
Yes.
and I'm also affirmative, so that's unanimously carried. So we will at this time, commissioners, leave the public meeting and go into executive session. Members of the public, thank you for joining us. We will resume the public meeting at 10:30. Jamie, do you want to add anything to that, please?
Yes, you can just use the same link to rejoin the public meeting after the executive session.
Thank you.
Mhm.
Good morning again, members of the public. We are resuming our public meeting of the Post Commission. We have a quorum in attendance, all those who were present earlier, except for Commissioner Crispin, who is unable to attend any longer today, although he was in attendance at the beginning of the meeting. I will at this time ask for a motion to approve the minutes of the February 13th, 2025 meeting. Is there such a motion?
So moved.
Is there a second?
Second.
Thank you. Let me take a vote on that, please. Hanya,
Yes.
Commissioner Calderon,
Yes.
Commissioner Hall,
Yes.
Commissioner Kajirosian,
Yes.
Mr. Talley.
Yes.
I'm also a yes, so that is carried. Moving on to the next item on the agenda, the Executive Director report. Please, Enrique, thank you.
Thank you, Madam Chair, and good morning, Commissioners. Let me share my screen in a moment and take you through my report, the report of the activities of some of the activities of this last month. as, give me 1 second. As members of the public know, and we already had a question this morning about this effect, the Post Commission does not answer questions at its public meetings. They can contact us in any way they choose. That's showing in the screen, postc-comments@mass.gov, or going through our website where there's a lot of contact information, including our main number, 617-701-8401. We know there's some interest by some constables to talk to us. We've reached out to them in the past, and we will do so again. As part of this update, I will also be getting into some of the details of the discussions around this topic as well. Okay, so I will be going, let's see. As part of my report, I will give you a brief certification update. As I mentioned, I will give you the update on the topic of constables since our last meeting. We'll follow by some administrative matters, and we'll close this report with a budget update. As I have given you an update in the past relative to the certification, the certification of officers, incumbent officers with last names A through H for the second time is fast approaching. We have discussed with the Commission before and started to implement a process for what we call a streamlined version of the recertification. All of the individuals whose certification is expiring on June 30th of this year will be up for the second round of certification by the Post Commission. This applies to approximately 8,000 individuals. The streamlined version, as again has been discussed with you and the committee and the subcommittee on certification before, will essentially consist of corroborating whether the officer is current on their CPR and first aid certificate. We will corroborate completion of in-service training for the training year 2025, which ends on June 30th. We will also confirm and ask agencies to submit any employment status changes. A big part of the certification process is frankly confirming the roster. Individuals may have dropped off, retired, resigned since the last round of certification. And although agencies are required to send us that information, we remind agencies of that. This process of recertification is an important milestone for us to really corroborate that all of that information is current in our records. We will also ask that any disciplinary matters since the last round of certification have been submitted to us, if they were required to be submitted or if they happened. And of course, the all-encompassing question about the attestation of the good moral character and fitness for employment as an officer. If that continues to be the case, then the officer will be recertified. If there's any of these instances in which that's not the case, there's either a lack of completion of first aid or lack of completion of in-service training, there will be a process like we normally do for a conditional certification with some period of time. Or if there's no attestation for the good moral character or fitness for employment, there's a process for appeal to appeal that decision like we have done in the past. All of that remains the same. We will come back with more details at the next commission meeting, the April meeting. And we are projecting that we will open the portal that every agency is familiar with by now around May 1st. Again, we'll come back with those details at the April meeting. We will also provide training on the modifications that we will make at the portal all around the time of portal opening. Again, in and around May 1st. I'll move on to an update on the constables, notably since our last meeting. Prior to our last meeting, we had received a letter from actually the trial court. That's not the housing court. And we also got a letter from the trial court general counsel that came after our last meeting. Essentially, in that letter, they're of the opinion that they disagree with our interpretation of arrest, which is based on prior court decisions. So we have a disagreement as to certain interpretations of certain provisions, notably the term arrest as it relates to this topic. That necessitates further discussion, as I will outline here in this and the next slide. In the meantime, we did a follow-up with the listening session that at the Worcester, I'm sorry, the listening session came after the Worcester PD meeting. We had a meeting with the Worcester PD that included a number of constables. General Counsel Ravitz and myself attended on February 21st. Some of those individuals heard from us for the first time, but I thought it was an important discussion to have about, again, this topic and our interpretation of this topic. Following that meeting on March 11, we had a community listening session, which was a follow-up to the initial meeting we had at the end of January with members of the community who have been affected or are interested in some way about the topic of these evictions and the role of constables in this process. That was again a fruitful discussion hosted by the YWCA, our own Commissioner Hall, and again, that was an important, good discussion. What we believe, and we've had already some necessary communications with members and staff at the legislature, is something that we need to continue to do, as I will get into in my next slide. Also, in the meantime, we are tracking, as I reported to you in the past, I've started to survey and ask agencies with associated constables to track those individuals and submit that information to us. I can report that as of last week, we have gotten responses from 344 agencies as to whether they have, and if they have individuals associated as constables, who those are. There have been, of those 344 agencies that have responded, 174 agencies have constables. I say here there may be more agencies with constables associated within their community, but I say this matter is ongoing, so this number, the 174, may increase, although I don't believe it will increase significantly. Of the 174 agencies with constables, they have notified us of 471 individuals, again, associated or operating within their community. This starts to give us an important way to contact and communicate with these agencies and these individuals on the matters that arise out of this topic. I mentioned or alluded to earlier, we've had some communication with the trial court, specifically their general counsel. We have an upcoming meeting with him and others to discuss what we see is a disagreement and explore potential areas where we do agree relative to essentially serving process, not executing arrests, but serving process, something that we have never intended to be something where the Commission or our regulations affect. Again, we will continue to have and inform the legislative delegation, especially the ones interested, the ones around Worcester, which is an area that has emerged as an area of significant interest. And we foresee that there will be the need to further define the term police duties and functions, which we have done in the past, but there may be a need based on all of these discussions to come back and present to you more nuanced definitions of this term of the statute. I'll move on to our annual report. We are required to report to the legislature our fiscal year activities for fiscal year 24 by March 15. We have done so. As part of that process, we also are including in the packet the annual report for the calendar year 2024. As commissioners might remember, we report to the legislature certain things that are included in the statute on a fiscal year basis, but our annual report for the activities that are in addition to all those activities that are required to be reported to the legislature is on a calendar year. Our annual report is also included in the packet. I will mention that as part of our communications process, we are now updating suspensions reports in real time. We used to do some of these updates in our website on a monthly basis by the end of the month, but given enhancements in some of our reporting, we are now updating our suspensions in real time. As soon as we make them, those reports go up on our website, and everyone who is interested and has signed up to receive real notifications receive those notifications. We continue to update our disciplinary records on a monthly basis, although it's not always at the end of the month. We recently just updated those disciplinary records. That was March 17. And we will come back to you and update you on our business intelligence tool. Those efforts are ongoing. The idea is that this business intelligence tool will enable us to do a lot more real-time reporting, just like we have done recently for the suspension reports. What we need to and are working to have more real-time reporting is, of course, the certification status of officers. That will be our first phase. And one day in the future, our disciplinary records, that process is a lot more involved in terms of review and update. But again, our business intelligence tool will enable us to eventually do that in real time. I also want to mention that we have added more content and some features in our website, including videos. This is with the intent to enhance engagement and, of course, continue to disseminate information like we are required to do. I'll mention briefly, as part of the administrative update, there are some important recent internal initiatives, notably around the legal department and our human resources effort. Thanks to the legal department, our commission decisions are available in the social law library, and they get updated there every time we issue a new decision. Anybody can then search the social law library on the way that they normally do. All of the decisions of the commission will be available there as they are in our website. Well, the general counsel and his team have also started an important initiative relative to internal seminars. I benefited tremendously from the most recent presentation, especially the one regarding the law governing the MPTC. That's an important topic, a broader one that I imagined. We are all bound to abide by the public records law, and we indeed get a lot of public records requests. It's always good to have a periodic seminar around this issue for every member of our own commission staff, and that has been proven very fruitful as well. We've added some a web page on victim resources. That's a topic that had been highlighted a while ago, and we continue to enhance our efforts to provide some victims some resources that may not be maybe available to them, especially state resources, which we link to directly. And we recently completed an in-person training on harassment and sexual harassment as part of our ongoing effort to do this type of training on a periodic basis. I'll move on to my my update relative to budget. As we've reported to you in the past, we are still targeting and spending and making some reconciliation about around our expenditures for fiscal year 25. We still project that our reversions will be around 600,000 back to of unspent monies back to the Commonwealth's fund. We will still have some activity on this year relative to some additional build out of our reception. There are some one-time expenditures associated with those, and we will be discussing with you the third quarter results in the April meeting. That will be ending March 30th. We continue to do work relative to the fiscal year 26 budget, and we are preparing. We're almost finalized with testimony that we will present in front of the Joint Ways and Means Committee of the Legislature on March 28th. That would be in Clinton, Massachusetts. We have done these presentations in the past in different places because the committees meet in different places. This time around, it will be in Clinton, Mass. Our original request is for 9 million, just shy of 9.5 million. And I'll remind commissioners that we have that House 1, the budget that was released by the governor is 570,000 less than that request. We intended to enhance and really start our audit program as part of this request, and that's the basis for why we the business case that we will be presenting to the legislature at that March 28th meeting, asking them to restore that that request so that we can really begin in earnest that audit process that I mentioned before. I'll close my report with a little bit of a human resource update, specifically around hiring. We welcome Cassidy Clark, our new intake coordinator, and 2 legal fellows, George Bowden and Olivia Scuncio. We have some additional resources planned. We have our deputy director for the Division of Certification starting in April 7. I'll introduce her at the April meeting. We have some additional legal interns that we envision, not just to help the legal department, but also potentially the Division of Standards. And we have, we're about to post or will soon be posting 2 additional positions as part of our ongoing efforts, the Record Access Officer for the Legal Division and an Information Technology Analyst with the Technology Division. Let me pause there and stop sharing and see if commissioners have any questions or comments. Madam Chair, I think you're muted, but with that, that concludes my report.
Thank you very much, Enrique, for your report, and thanks to all members of the staff who have worked with you on the matters that you have addressed. Let me move on then to item number 5 on our agenda, the legal update, and I will turn to our General Counsel, Randy Ravitz, please.
Thank you, Madam Chair. I will turn the floor over to Annie Lee, counsel in the Legal Division.
Thank you, Randy. I'll actually turn the floor over to our paralegal and hearings administrative officer, Lizzie, who will be handling the first 2/3 of the next topic.
Thank you, Annie. Commissioners, I'm just going to share my screen, so bear with me while I do that. Okay, Can you all see it? Yes, okay, perfect. So good morning, commissioners. Today, Council Lee and I will present the results of the survey that we sent to unions. I do want to note that the data we are providing today is not representative of all unions. The information contained here just represents the responses that we've received to date. If there are any members of union leadership that have not submitted a response or have not received the survey, you can contact postc-comments@mass.gov. And this email is also provided in the last slide of our presentation. So this presentation and corresponding memo are for informational purposes only. So at this time, the commission is not being asked to vote on any matters related to physical fitness and behavioral health. So with that, I'll provide a brief agenda. So we're going to go over the process of sending out the survey, go over the results, and then compare the results of this survey with the agency survey that we sent out earlier last year. So to go over the process of the survey, it was developed to collect similar information as the agency survey, and we received input from Post and MPC staff on the questions so we can best elicit information. And commissioners, feel free to stop me at any time if you have any questions. Let's see. Okay. So the agency survey that we sent out in November was we received 213 responses from agencies, and we presented the results to the commission at the December 2024 public meeting. And the union survey was sent out January 3rd, and responses were due by February 21st. We did extend the response deadline. It was originally earlier in February, but we wanted to ensure that as many unions got to respond as possible. So this is a survey at a glance. We've had 60 unions respond. The largest union surveyed was 12,000, represented 12,000 sworn officers, and the smallest union surveyed represented 5 sworn officers. So in general, most respondents of the survey represented local chapters for small to mid-sized agencies. So the first question that we asked regarding physical fitness was what resources unions successfully bargained for. We asked this to get a sense of the resources and opportunities that are available to officers and what they want unions to bargain for. A majority of the respondents successfully bargained for on-site gyms and fitness centers. And the second most popular response was on-duty time to exercise and other. And the other category allowed for further explanation, and some of the answers were earned time off for logging a certain number of workouts per month, incentives for passing fitness examinations, and department-sponsored medical or health screenings. So the next question asked unions about physical fitness opportunities that they unsuccessfully bargained for. And the most common answers were on-duty time to exercise and reimbursement and stipends. So like the previous question, we included an other option to give unions the space to provide further explanation. And some of the things that unions unsuccessfully bargained for were an annual fitness test with stipend, wellness incentives broadly, and days off for logged gym use. This question asked unions what officers want them to bargain for next. And we asked this to get a sense of what resources and opportunities officers are interested in and want. So most reported that officers want on-duty time to exercise, reimbursement stipends, and free or discounted access to off-site gyms and fitness centers. This question asked about officer participation of available resources, and most unions reported moderate to low utilization of physical fitness resources. And the next slide will go over the challenges identified for maintaining physical fitness. So overwhelmingly, the largest challenges to maintaining physical fitness were time, motivation, and expense. And some unions mentioned that officers work extra details and long shifts, which cuts into their time to exercise. So this question asked unions to rate the overall physical fitness of officers they represent. And most unions rated overall officer physical fitness as fair to good. And this question asked unions to say what they think physical fitness recertification requirements should be. And the most common suggestion was a standard fitness test or Cooper test. And multiple responses emphasized the importance of accounting for an individual's age, gender, and job duties. The next most popular response is none. Officers are worried about having another exam to complete, and they acknowledge that it may make it more difficult to retain officers and recruit if there are additional evaluations. So in the other category, some responses included incentive-based, non-punitive fitness tests, a physical ability test, and a medical exam or physical. So I want to pause here for questions before I move on to the behavioral health section of the survey. And I'm not seeing anything, so I'm going to proceed. So this section asked what, and sorry, the behavioral health section mirrors the questions from the physical fitness section. So we're going to start first with what behavioral health resources unions bargained for successfully. And the most common answers to this question were employee assistance program referral to a mental health professional, and it says EAP in here. And the next most common answer was critical incident debriefing, and that's similar to what the peer support network does. A number of unions also reported other for this question, and those responses include that many behavioral health resources were actually provided by the department or municipality and not through contract negotiations. So that was interesting to learn. And other responses included mental health days and SEMLEC support. And for those who don't know, SEMLEC is the Southern Massachusetts Law Enforcement Council, and it's a consortium of law enforcement departments of 30 cities and towns in Southern Massachusetts. This next question asked unions about behavioral health resources that they unsuccessfully bargained for. And a majority of unions that responded to this question indicated that there were no behavioral health services or initiatives that they unsuccessfully bargained for. And other behavioral health resources that unions tried to bargain for were wellness visits and a relationship or partnership with a mental health consultant. This next question asked what officers want unions to bargain for in terms of behavioral health resources moving forward. And the behavioral health opportunities the officers want are critical incident debriefing, periodic evaluations by a licensed mental health provider, and a relationship or partnership with a mental health consultant available to officers. So I think this data shows that officers want access to mental health professionals that they can trust. And we'll go into more detail on this later. So this isn't surprising, but most officers do not feel comfortable accessing behavioral health resources or services. And we recognize that there are many barriers preventing officers from accessing the available resources. And we cover that more in the next slide. So the biggest barriers reported were stigma, fear of adverse employment outcomes, time, and post-commission and police reform. The point of the behavioral health evaluations is not to punish officers for seeking help. So we do want to normalize seeking help and change the culture around mental health for law enforcement officers. So this question asked unions to rate the quality of behavioral health services available to officers. And a majority of respondents answered good and fair. And we acknowledge that it's going to be a challenge to make resources and access the same for all departments. So some ideas that unions submitted for behavioral health recertification requirements were none. And honestly, the answers to this question varied a lot. Most respondents to this question believe that there should not be any behavioral health requirements. Officers have valid concerns about privacy and the effectiveness of applying a one-size-fits-all approach to behavioral health. And we acknowledge the officers experience and handle trauma differently. So this is just another nuance that our agency will have to be cognizant of as it develops behavioral health requirements. Other responses suggested mental health check-ins or wellness visits based on the peer support model. And a few specified that the commission should not have access to the meeting information and no lawful actions should be taken unless there are clear and obvious signs that the person is a danger to themselves or others. And another response included evaluating agency leadership and their impact on officers. And so they said municipalities should implement ways to reduce officer stress from upper management, and the town should enforce that. And then some supported an as-needed approach to behavioral health appointments. So like critical incident debriefing, or if the officer is identified as needing additional support. So those are the results of the union survey. Before I turn it over to Annie, do any of the commissioners have questions about this? And, Commissioner Busto?
Yeah, thank you so much. This is really wonderful feedback. And I think just such a sort of nice opportunity to think about the way that we can be supportive of increasing resources. One of the things I noticed from some of the additional data that I reviewed is, which sort of was interesting and I hadn't considered, is that there was some subset of people who talked about the value of having literature on hand. I just wanted to make that point, that that's a sort of a simple way that we can provide some information to departments and to officers, and something for us to consider.
Yeah, thank you for mentioning that. Yeah, I failed to present on that, but yes, there were a couple respondents that said that officers should be educated and remain aware of the resources available to them. So thank you for bringing that up. And I don't see any other hands. So with that, I'm going to turn this over to Annie.
Thank you, Lizzie. So the next question that we wanted to understand just among staff was, how do these results, how do the responses from the union survey stack up against the results from the agency survey, which were presented to the commission in December? And so thank you, Lizzie. And so when it came to the first part of this question, which is ideal standards and evaluations regarding physical fitness, the most popular answer for both agency chiefs and union leadership was a physical fitness test, which Lizzie mentioned earlier is referred to in the law enforcement community as the Cooper test. And so this is what you would think of as sort of your standard physical fitness test. It typically consists of a cardio event, usually a mile to a mile and a half run, as well as strength events. And these are typically push-ups and sit-ups and the like. And so responses that we saw in both the union and agency survey noted that the Cooper test would be appropriate for recertification because that is what is currently required at the academy level. and this specifically at MPTC run academies. And so we saw responses that said, whatever the academy requires should be what is required throughout an officer's career for consistency. We will note, however, that both unions and agencies said that the standards for the Cooper test, which means sort of the minimum time for a run, the minimum number of push-ups and sit-ups, that should scale to account for an officer's gender, age, and if relevant, any injuries the officer may have sustained on the job in order to reflect the change in physiology that's associated with aging and also the number of years of service. After that, unions and agencies both agreed that other acceptable options for physical fitness standards and evaluations would be the physical ability test, which is what's currently required of civil service candidates, medical exams, meaning an annual physical, and incentive-based programs, though they differed in their preferences among these options, as you can see here. We will note for the commission that both agencies and unions indicated a high preference for having no physical fitness standards and evaluations. Agencies indicated that this was their third preferred option, and unions said that this was their preferred second option. And so the responses for why the commission shouldn't set sorry, Lizzie, if we can just go back to the previous slide. Thank you. So the responses for having no standards and evaluations from both agencies and unions shared things in common, which is that physical fitness is highly individualized. Some officers do really well with cardio tests, some do with strengths, and many officers have their own preferred ways of maintaining their physical fitness that won't necessarily translate to a uniform test. So for example, if you have an officer who likes to do kickboxing, that's not necessarily going to translate to a 1.5 mile run. And then if you have officers who enjoy sort of lifting weights, that might not also necessarily translate to the 1.5 mile run. And agencies and unions also expressed fear here that uniform standards and evaluations for physical health could come at the expense of losing experienced officers who are really skilled at their jobs, but might not be able to meet these sort of uniform standards and evaluations right away. And so they expressed this fear of this trade-off for really experienced officers who may not be as physically fit as desired, for younger officers who are physically fit, but just don't have the experience to necessarily be able to perform the job at the same level as those veteran officers. Lizzie, if we can go to the next slide. And so while unions and agencies were generally aligned and had sort of common responses for physical health, we saw that agencies and unions differed quite a bit in their responses on ideal behavioral health standards and evaluations. Agencies overwhelmingly indicated a preference for periodic mental health check-ins, which are also referred to as wellness visits. And as Lizzie alluded to, these are sort of annual visits with some sort of licensed mental health provider, where an officer goes, they're required to go, but they're not required to necessarily talk to the mental health provider who is there. And so it's essentially a check-in for the officer if they need it. They're required to go, but they don't have to participate. In contrast, unions stated that there should be no behavioral health standards or evaluations, and they said so overwhelmingly. Some unions said that requiring officers to meet behavioral health standards and to undergo evaluations for recertification would be intrusive. And they also raised concern that these evaluations are subjective because it depends on who the evaluator is. And these evaluators may not have the cultural competency to evaluate officers who work, just because simply that's not a population that is necessarily standard as to sort of the general public. And then while agencies generally indicated they were in favor of behavioral health standards and evaluations, some agencies also shared these fears and therefore indicated a preference for having no behavioral health standards and evaluations. In support of this, they raised what Lizzie identified previously in the challenges, the sort of the stigma, fear of adverse employment outcomes, as well as the post-commission and police reform generally. And by that, we mean that sort of agency chiefs responded that officers are more hesitant to go to their chiefs or to go seek mental health treatment because they're afraid that word will get back either to their agency or to the post-commission and all of a sudden their certification status and their ability to maintain the job of a police officer might be called into question here. And so, when after that, when unions did indicate an appetite for behavioral health standards and evaluations, they tended to agree with agencies that mental health check-ins and wellness visits could be useful. But they also indicated that maybe mental health check-ins and wellnesses shouldn't be on like a periodic basis, whether that's annually or triennially, but rather as needed, meaning that officers should not be officers should be evaluated after a certain triggering event occurs, whether that's a critical incident or something personal in their lives, or if they're flagged by their agency as requiring an evaluation. This was the second preferred option among agencies, so there's a little bit of overlap there. But the other options that agencies sort of flagged for the commission's consideration, which is training and education on available resources, as well as sort of full psychological evaluation, similar to what is conducted at the academy prior to hiring, unions didn't express a preference for those options in nearly sort of the same measurable way that agencies did. And so happy to answer any questions that the commissioners may have. Otherwise, happy to turn it back over to the chair. Commissioner Blueston?
Hi, it's me again. I just wanted to make a quick point about the wellness visit, just to obviously highlight that in the absence of any kind of behavioral health component, that there seems to be a preference towards the wellness visits, and some departments have already initiated that. I think that it's just important to highlight that the model includes a licensed mental health professional and also a peer. And that's one of the reasons that the model, I think, has been successful. And it's one of the models that has been implemented in other states as well. But as we sort of think about this and consider the options, one of the big barriers here is the cost of an in-person visit with a mental health professional and a peer, as well as the difficulty with time off to allow an officer to avail him or herself of that opportunity.
I don't think I see any other hands in the air. And at this point, again, let me thank the presenters for the information that you provided. Randy, back to you.
Yes, thank you. The next item on the list under the legal update is a proposed policy on voluntary relinquishment of certification. And that policy is included in the commissioner's meeting packet. And I'll be talking about its key provisions, but we do not expect to be asking for a vote on the proposed policy today. In general, the policy would provide a way for an individual to voluntarily relinquish a certification as a law enforcement officer, while at the same time building in certain safeguards in case that individual has engaged in any misconduct that might warrant action by the commission. Now, the commission previously considered a policy in this area, but some concerns were raised, so it was modified to instead simply provide a way for an officer to have certain information removed from our public database. But since then, we've been asked again about the possibility of relinquishment. And so this new version represents another attempt drawing from the prior proposal in certain ways, but also aimed at addressing concerns that were aired when this previously came before the commission. So in section 2, the policy would first provide for an individual to submit an application for relinquishment that is on a form that calls attention to the terms of this policy, that requires an applicant to provide details regarding criminal matters and relevant civil and administrative agency matters in their background, that would require them to agree to the terms of the policy, which I will be elaborating on in a moment, and that requires them to attest to the information they provide under the pains and penalties of perjury. Then moving on to section 3 of the proposed policy, it would provide that when the executive director or a designee receives a sufficient application, that person would provide it to all staff divisions and afford each one the opportunity to raise any issues. And that person would also review information in the application. And I think that section of the policy, by the way, can be adjusted a little bit so that it correlates to the description of the application materials more closely. But that person would also review disciplinary information that the commission has obtained, entries in the National Decertification Index, if there are any, and other information in the commission's databases. That person would also post the application on the commission's website and invite public comment, and they could invite comments in any other way. They would then provide all of that to the chair, along with a recommendation on whether the commission should grant the application, and if so, whether any additional conditions should be attached, additional to those already stated in the policy. Those same questions of whether to approve the application and whether to attach any additional conditions would be put before the commission at a meeting. And then the commission could either grant the application or grant it with additional conditions or deny it entirely. But if the commission is inclined to add any additional conditions, the applicant would first be informed and given the opportunity to instead withdraw the application. Now, section 4 of the policy outlines the terms and conditions of relinquishment, which again, the applicant would have to agree to. And what it provides is that upon relinquishment, the applicant could no longer be appointed or employed as a law enforcement officer or execute arrests or perform police duties and functions in any manner, even through details. But as to any conduct that occurred when the applicant was certified or was employed as a law enforcement officer, or that occurred as part of the application process, the commission could still take disciplinary action and could still submit information to the National Decertification Index. And to the extent that the commission has any concerns about taking action against someone who has relinquished their certification, it could do so by reconsidering the decision to allow that relinquishment, vacating that decision, and restoring the certification with any appropriate limitation, condition, restriction, or suspension. So in other words, the certification would be restored for the purpose of taking disciplinary action. And whether the individual's information remains in the public database would continue to be governed by other policies previously adopted by the commission for that purpose. So again, we're not asking for a vote at this meeting. As always, we'd be happy to receive any comments from anyone inside or outside the commission. And I can entertain any questions if the chair would like me to do so.
Thank you very much, Randy. Charlene, did you have a question? No, I don't think I see any indication that the commissioners have questions. And again, thank you very much for the presentation. I think with that, we have concluded, have we not, the matters on the agenda?
Madam Chair, if I may, I think we have one more item related to agency certification.
And I'm sorry, where is that, please, Annie?
I believe that's 5B.
Okay, go ahead, please.
Thank you, Madam Chair. Let me just share my screen quickly with the commissioners. All right, thank you. So today I plan on presenting proposed revisions to the draft use of force and reporting standards. I'll note at the outset for you that I am going to be seeking preliminary approval of these two standards. But first, a quick review of the process. We started this process in August last year, and we're last before you in December when the commission reviewed a second set of revisions that came out of October and November meetings between the commission and MPTC staff. The commission did not preliminarily approve those revisions or standards during the December meeting, because while the MPTC indicated during its own December meeting that it was pleased with many of the revisions, it also indicated that it would like the commission to consider further revisions. the MPTC followed up on its December meeting comments with written feedback in February. And during this time, the Commission also received written comments on these two standards from the Attorney General's office in January, as well as strategies for youth in February. And so the revisions that came out of MPTC's December meeting and February correspondence, as well as the Attorney General office's January comments and strategies for youth February comments, will be the focus of my presentation today. And so those revisions concern two elements of the use of force and reporting standards, specifically de-escalation in the use of force standard, as well as public complaints in the use of force reporting standard. And so to the first revision, there are four in total that I'll be presenting today. The first revision before you concerns the definition of de-escalation tactics. The revisions here that you see, so in that second paragraph, I've underlined and put in yellow the new language and done a strike through on language from the prior definition that we're proposing the Commission remove from this draft standard. And so this revision arises from a comment that was submitted by the Attorney General's office in January. That comment letter is included at page 125 of your meeting packet. And so in its letter, the Attorney General proposed revising the definition of de-escalation tactics to, quote, avoid possible confusion and to emphasize that critical thinking skills are consistent with, and indeed a common sense component implicit in, de-escalation tactics, end quote, as described in the Commission's use of force regulations and guidance, as well as MPTC training materials. The AGO noted that the prior definition of de-escalation tactics was, quote, appropriate in substance, end quote, but suggested that the definition would benefit from emphasizing that critical thinking is, quote, a useful and necessary tool to help evaluate the options available to diffuse tense or dangerous situations, end quote. And so what we've done here in these revisions is adopted the Attorney General office's suggested definition, which makes critical thinking part and parcel of de-escalation tactics. Although this comment or this revision came out of a suggestion by the Attorney General's office, we did consult with the MPTC on this revision, and they did indicate that they thought this was a good revision. The next two revisions also concern de-escalation, but they concern the use of critical thinking skills to consider whether non-criminal factors may impact interactions between an officer and any given individual, such that an officer may need to modify their de-escalation tactics and techniques to respond to the particular individual in front of them. And so the first of those two revisions, which is in yellow on your screen, comes from feedback that MPTC provided in December and followed up on in February. And so the MPTC in December and February raised concerns that requiring officers to make efforts to ascertain whether an individual's lack of compliance is based on non-criminal factors may cause officers to hesitate during an encounter because they're thinking, okay, like, is this person's reaction based on mental or physical condition, language or cultural differences, the legacy of policing, agency's history with the public? The MPTC raised concerns that this could require officers to essentially have to go through a checklist in a really fast and potentially dangerous encounter, which would further create a potentially dangerous situation, not only for the officer, the individual involved, but also other members of the public who may be around at the time. And so the MPTC suggested that instead of having this as a proactive requirement in the moment, to instead move this to use of force reporting to consider whether non-criminal factors affect an individual's compliance with an officer's directives. So to essentially, after a use of force incident has occurred and it's been reported onto the agency as well as the post, to then think about, okay, were there any non-criminal factors in play that could have affected how this incident played out? And so in response to that, I want to clarify for the Commission here that in drafting this section, the intent was really to increase officers' awareness as a general matter that an individual's particular lived experiences, whether those are related to mental or physical condition, language or cultural difference, or historical experience with policing, may cause them to react to law enforcement in ways that are not criminal, but to officers may first appear as opposition and noncompliance. And so the ultimate goal of this section was to really improve outcomes between officers and individuals by encouraging this heightened awareness and modification of de-escalation tactics and techniques as a result. And so really the intention here was to call for officers to proactively consider that an individual may be impacted by their personal experiences and characteristics that have not always historically been considered by law enforcement, especially those things that are experienced by populations and communities that are disproportionately impacted by policing. And so rather than taking the MPTC's sort of suggestion of moving this into use of force reporting and making it sort of an after the fact consideration, we revised this language to try to make it clear that this is really important to do proactively, but also this is not something that is necessarily only done at spur of the moment. It's something that will come from sort of a general heightened awareness. And so we proposed revising this section so that officers are encouraged to be conscious as a general matter of historically overlooked non-criminal factors when responding to a particular incident, so that officers can engage in this proactive critical thinking and mitigate any concerns that officers are asked to engage in critical thinking at the expense of theirs and others' safety. And so this was presented to the MPTC during its public meeting, which was actually conducted this Monday. And MPTC indicated that it found this revision reasonable. And so the second of two revisions in this section that I want to bring to your attention, it's in green here, comes from a comment letter submitted by Strategies for Youth in February. That comment letter is included at page 129 in your meeting packet. And so Strategies for Youth in its letter suggested that the commission include in its grouping of non-criminal factors the specific group of age or developmental status. And they said that, quote, there is a dearth of youth-specific policies, standards, and training such that explicit reminders to officers to take age and developmental stage into account are essential for fair and effective policing of youth. And so we've adopted Strategies for Youth suggestion here, or propose adopting it, and inserting age or developmental status into the description of non-criminal factors. And finally, the fourth revision before you concerns public complaints regarding use of force incidents. Both MPTC and Strategies for Youth raise the same concerns, which is that a protocol for individuals to follow up on or raise concerns about a use of force incident might not be sufficiently clear. And they suggested reverting to prior language that called for agencies to establish a protocol for individuals to, quote, file a complaint, end quote, about a use of force incident. They just suggested that follow up on or raise concerns wasn't sufficiently clear and didn't necessarily give the public sort of the knowledge that they could file a formal complaint that comes with certain procedures. And so we therefore adopted the suggestion that MPTC and Strategies for Youth made and reinserted complaints such that agencies must establish a protocol for individuals to follow up on, raise concerns about, or file a complaint about a use of force incident. And the reason that we kept follow up on, raise concerns about, and then added or file a complaint about is to make clear to members of the public that they can file formal complaints, but also that, you know, if they're intimidated by the formal processes that might come with filing a formal complaint, there are other avenues by which that individual can still sort of raise concerns or ask questions of the agency about a specific use of force incident. And if that eventually results in a formal complaint, there's also a process to follow there. And so during MPTC's Monday meeting, they reviewed this revision, and they also indicated that they found this reasonable. And so, Madam Chair, if you would like me to entertain any questions, I'm happy to do so. Otherwise, I'll suggest again for this commission that it doesn't appear that there are any outstanding comments or feedback for the commission. So I would suggest that this is appropriate for preliminary approval as a draft.
Thank you. I think Commissioner Kazrosian has a question, and then I also do as well. But go ahead, please, first, Marcia.
It's really more of a, I just wanted to commend you and everyone who worked on this, because I know how much work this was, and at times it got difficult, and there's a lot of interaction with different agencies and incorporating everybody's comments and suggestions. And I just think that you've done a wonderful job with this, and I support an initial approval of this. You did a great job.
Thank you, Marcia. And my question, Annie, has to do with that suggestion on age or developmental status being added. What does developmental status, I should probably know the answer to this, but what does developmental status mean?
Thank you, Madam Chair. I believe in the way that Strategies for Youth conceives of it, developmental status is very much associated with age. And so essentially that the juvenile brain is not fully developed, and that even extends to young adults. So I think that they would point to research that shows that the prefrontal cortex doesn't really stop developing until your mid-20s. So I think they would sort of suggest that's what needs to be taken into account, that young adult decision-making is not necessarily as ripe as adults who are in their late 20s and above.
Thank you. Commissioner Bluestone, please.
Yeah, it's a good point, and I wonder if more clarification might be helpful, because for me, developmental status also refers to individuals who may not have met certain developmental steps within an age expected way. So for instance, individuals who might have autism or other kinds of developmental or mental health conditions would be considered in that category. But I'm not sure that just saying that really gives the people reading it much information about what we actually mean. So it might be worth looking into a little bit more.
Thank you. Commissioner Luma?
I was just gonna kind of reiterate what Hanya said. I think there is specific milestones and expectations that we would expect young people to meet based on where they are at in their age. But there can be some variables that impact that development. And so I think there does need to be more clarity around that.
Thank you, commissioners. Sorry, Madam Chair.
No, go ahead. I was going to ask you to respond, please, Annie.
No, thank you very much, Commissioners Luma and Bluestone, for that. I think that there is also sort of that conception of developmental status within Strategies for Youth. I can certainly go back and ask them to clarify it, so we can either we could potentially define it. There may also be some overlap between developmental status and mental condition. So there may be, I agree that that could benefit from a little bit of clarity. I will note for the commission, though, that per the use of force regulations at 6.10.2, the commission and the MPTC will jointly develop a model use of force policy, and that could be very well clarified here. Under the use of force regulations, agencies are called on to adopt a use of force policy that is consistent with the commission and MPTC's use of force model policy. And we've heard from MPTC that many agencies will probably adopt verbatim as much as they can the commission's model use of force policy. So that's one way in which we can clarify.
So what you are, thank you, Annie, what you are asking, I guess Commissioner Luma has another question at this point, or comment.
I just, the language around consciousness, I can't remember what section that was in regards to, I'm sorry. Can you go back to that slide?
Yes, let me just share. I think you're referring to critical thinking and de-escalation. I don't believe consciousness appears
maybe conscious.
Oh yes, encourage officers to be conscious of non-criminal factors.
Okay, so I guess I know that this is kind of the suggested language, but how do we assess for that? You know, if we were kind of determining whether or not an officer actually was conscious of these factors, how do we assess for that is my question.
Thank you, Commissioner Luma. And so I'll clarify here that these are standards for agency policies. So we're not necessarily going to be assessing every single officer about whether they're conscious of these non-criminal factors. This is similar to a question that was raised by MPTC during its Monday meeting. And so what the MPTC discussed is that something like this that is a little bit sort of idealistic, it's a little bit general, can be appropriately placed in an agency sort of policy statement when it comes to use of force or to sort of general directives. to be conscious, just this increased awareness. I agree with you that it can be very difficult to measure, especially in a quantitative way. And so that's why it might be more appropriate for sort of a statement of purpose or a policy statement.
Thank you.
Are there any
And
other?
again, oh, sorry, Madam Chair, I was just going to say, this is something that would again sort of be clarified in the model use of force policy. That would, of course, come before the commission for its review and approval.
So what are you asking us to do today, Annie?
So I was seeking the commission's sort of preliminary approval of these two standards as draft. And so, as we're all aware, this is going to result in a larger regulation that will be promulgated through a formal notice and comment period, but we're doing it piece by piece just because that regulation will have so many components to it. So this is essentially kind of, like I've said before, sort of a conceptual thumbs up so we can move forward with this guidance from the commission in developing and starting to develop a model use of force policy and can move on to other topics in agency certification.
Well, I just had one comment based on what was last discussed. Would it be better said that officers should be aware as opposed to officers should be conscious?
We could certainly make that revision, Commissioner Talley. Can certainly, I can accept, we can consider this sort of an oral revision to it, and then I can follow up on it, just putting in writing.
Okay.
But what you are asking us now is simply to preliminarily approve. Is that it?
Correct.
Okay. So with that, let me ask the commissioners whether they would approve a preliminary approval. Commissioner Bluestone, please.
Just a clarification, I would approve, I would certainly approve, and it's a wonderful job that you've done. I would just ask for additional clarification around that developmental issue.
Thank you. Commissioner Calderon,
Yes.
Commissioner Crispin. I'm sorry, he's not in attendance at this point. Commissioner Hall,
Yes.
Commissioner Kasserosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley.
Yes, incorporating suggested feedback.
Thank you. And I also approve, consistent with what Commissioner Bluestone indicated as well. So with that, we have the approval. Anything else from a legal perspective we have to address? Anything else, Randy?
No, thank you.
There are no matters not anticipated by me at the time the agenda was circulated. So I think with this, I would entertain a motion to adjourn.
So moved.
I think I can just take a vote at this point. Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Priskman. He's not here. Commissioner Hall,
Yes.
Commissioner Kasserosian.
Yes.
Commissioner Luma,
Yes.
Commissioner Talley.
Yes.
I'm also affirmative. Thank you all very much. Thanks again to all the members of the staff for extraordinary work and for the manner of your presentation today. So I think with that, this public meeting is concluded.